So Heather, I was wondering, how is this type of motion different from other types of motions?
This type of motion is different when it comes to evidence because the courts are expecting the litigants to put their best foot forward, to put all of their evidence that they have in respect of their case, in support of their case, before the court. So you're not supposed to leave key evidence out, in the event that you lose, and then you can use this evidence at trial. The point is, if you have the evidence, it's supposed to go before the court, and it's the best evidence. The court doesn't really want to see secondhand information in a lawyer's affidavit in support of a key issue in the case. If there's a first party witness, someone that has seen the incident, and their knowledge and their firsthand knowledge is important for the court to consider, then they want to see an affidavit from that person and maybe a cross-examination of that person. But they're not looking for lawyers or for lawyers' law clerks to put affidavits in and to attach exhibits of expert reports and whatever else they're relying on, and then putting that forth as material for the summary judgment motion. If you have an expert and their evidence is important, then ideally on the motion, the affidavit would be in the name of the expert and not in the name of some law clerk appending the expert report. So when you're looking at a summary judgment motion, the rule is best foot forward. All the evidence that you have is being put in before the judge. And the court will assume that they have been given all the evidence that would be available for trial. And on the basis of the record, the court decides whether it can make the necessary findings of fact, apply the law to the facts, and achieve a fair and just adjudication of the case. If the court can't grant the judgment, then the court will decide the issues that can be tried, if any are possible, identify additional steps that will be required to complete the case, and in the absence of compelling reasons, the court will seize itself of the further steps required to bring the matter to a conclusion.
That is an excellent explanation. So a motion for summary judgment, it's the way I think of it is it's almost like a more serious type of motion than your regular motion. I believe that in regular motions, you're allowed to have evidence that's like based on belief. Am I right?
So on a summary judgment motion, if you have an affidavit, you can be allowed hearsay, but usually that exception for hearsay, the exception for hearsay in an affidavit is that it's not controversial and that it's something that the parties can kind of all agree on. So if you're having a summary judgment motion and you're trying to put hearsay in that's even a bit controversial, then the counsel or the litigant should think twice about that and should try to find a way to put evidence in from that first person, that person that has the firsthand knowledge. So it's like the affidavit of the lawyer attaching an expert report. That's hearsay. They didn't write the expert report. They didn't do the observations. They didn't make the conclusion. In some cases, in some contexts, that might be okay in the form of hearsay. But on a summary judgment motion, the court is looking for people to put the evidence in first person and to give the parties the opportunity to cross-examine. Because of course, if we have cross-examination, if the party that is saying they heard or seen or made an opinion can be cross-examined, then we're not really engaging the hearsay rule.
That was really interesting. Yeah, of course. And of course, before the motion for summary judgment hearing, the parties are allowed to cross-examine on the affidavits. Is that correct? Right.
Yes, and factums are required for summary judgment motions. So if you're writing a factum for a summary judgment motion, the important thing is that you are pinpointing to the judge the key evidence that they need to consider. Make the judge's job easier. Don't just dump thousands of pages into the judge's lap and say, here, go figure it out yourself and see if you can make a conclusion. That's not ideal.
Right, of course, yes. I hope no judge wants to do a lot of reading for nothing. So it's basically be very prepared before you even get to the factum step. That you have to get all your ducks in a row, so to speak, right? You have to get your cross-examination done. You have to do your homework in reviewing the transcripts and picking out the most relevant and the most material parts.
Yeah, and the thing also is, I've seen it happen where a lot of lawyers want to just attach discovery transcripts
Yes.
to an affidavit and call it a day.
Yeah.
Say, look, I've done a summary judgment motion. It can be done. A lot of time the lawyers agree to it on both sides. We're just gonna put in the discovery transcripts, but that's not really in the spirit of the rule, which is putting in evidence from the first hand, like first party, the first party that sees it, putting that in an affidavit, and having that person having the opportunity to cross-examine that person. So sometimes counsel will choose not to cross-examine someone, but the courts want to feel comfortable that they're getting the best evidence and that what needs to be cross-examined has been cross-examined. And the court will assume, so if you give them discovery transcripts, they're going to assume that this is the best evidence that you can put forward.
That is really interesting. Okay, so that was great, and you're right. Okay, absolutely, that's really important to include. Yeah, the best foot forward. I think probably it just kind of like goes through people's heads.
Yeah.
Because if you're thinking, always a motion is a motion, but no, not all the motions are the same. And this one, there's actually a higher standard for the evidence that's presented, that's submitted. That's really good.
Yeah, exactly.
Excellent. Okay, now just a couple more questions. What are some of the possible outcomes of a motion for summary judgment then?
Well, the possible outcomes for the motion is you'll win and you'll get a judgment and the case will be decided in its totality, like the whole case, like the plaintiff wins, the defendant loses. Another way it could be decided is maybe part of the case is decided, the judge says, you know what, I can decide issue 1, but there's still issues 2 to 5, and those will have to go to a trial. Or the court might say, we need all the evidence, we need to have a full trial, we need all of the witnesses in a courtroom, we cannot decide it in this manner. And if that's the case, if there's one issue or all the issues can't be decided in a motion, then you're going to look at Rule 20.05. And under that rule, the courts will then, generally the judge will be seized of the matter, so they'll stay on as the presiding judge to hear further upcoming motions or issues. And they might put in certain type of like a schedule for exchange of expert reports, or a schedule for further discoveries, or a schedule for when productions are going to be exchanged, and maybe some case conferences. There's all this discretion for the judge to build the case going forward, to preside over that, and to help move the action along towards trial.
Oh, that's really interesting. Now, suppose parties go through a motion and they don't like the result. What can they do?
If they don't like the result, they can appeal the decision, and yeah, that's what you can do. Okay,
basically it just goes to the appeal courts. Wow, that's a lot of really important information to understand about motion for summary judgment. Thanks so much, Heather.
Thank you for having me.
And we are going to provide in the description below some additional resources that people can access to understand more about this type of motion. If you're new to the channel, don't forget to hit the subscribe and the notification bell so that you'll know when our next video is coming out. I want to thank everyone for watching, and thank you, Heather, for telling us about the motion for summary judgment. And we'll see you next time. Bye.